Hello everyone. In this presentation, the rules pertaining to the relevancy of facts under sections 9 to 11 will be explained. Now, so far as section 9 is concerned, it deals with relevancy of such facts which, although not connected with the facts in issue, but are necessary to explain or introduce a fact in issue or relevant fact. This section makes relevant the following facts: facts introducing a fact in issue or a relevant fact, facts explaining facts in issue or relevant fact, facts supporting or rebutting an inference suggested by a fact in issue or relevant fact, fact establishing the identity of any person or thing whose identity is relevant, facts fixing the time and place at which any fact in issue or relevant fact happened, and facts which show the relation of parties by whom any fact in issue or relevant fact was transacted. Individuals, events, or things cannot be suddenly introduced in a court of law without providing the necessary backdrop and connection to the case on hand. When the question before the court is whether the document is a will of A, the state of A's property and his family details at the date of the alleged will be relevant facts. In a suit filed by A against B for inducing breach of contract or service made by him with C, the statement made by C to A while leaving his service that the reason for leaving A was to join B, who made a better offer, would be relevant as it explains C's conduct, which is a fact in issue. Facts which support or rebut an inference suggested by a fact in issue or a relevant fact can be proved under Section 9 of the Evidence Act. Thus, where A is accused of committing a crime, the fact that soon after the commission of the crime, A absconded from his house is relevant under Section 9 as it supports the inference that he committed the crime. The fact that he had gone to attend on his mother, who became seriously ill all of a sudden, is also relevant as it rebuts the inference suggested by the fact in issue that he committed a crime. Facts which show the identity of anything or person whose identity is relevant is provable under Section 9. In case of theft, when the stolen property is recovered, the identity of such stolen property is required to be established. So also, in the case of murder, the identity of the weapon with which the murder was committed is to be established. Facts which prove the identity of these objects are relevant under Section 9. Now, one of the methods used for establishing the identity of a person as the person who committed a particular act is by means of test identification parades. When the crime is reported to the police and some description of the suspect is given, the police investigates and arrests a particular person as a culprit. The complainant is then taken to the police station to identify him. If the complainant picks him out, the police know that the witness is telling the truth and also that they are on the right track. To confirm the identity of the accused and help the police in their investigation is one of the main purposes of the identification parade. But where the witness knew the accused, there is no need to hold the identification parade. Another very important use of such parade is to use them as corroborative evidence. There is a long time gap between the commission of the crime and the trial, and if the accused is a person unknown to the witness, a question would automatically arise as to how the witness is able to identify the accused in court as the man who committed the crime. He had seen the accused for the first time on the day on which the crime was committed, and that too had only a casual glimpse of him. Long afterwards, during the trial in the court, he gives evidence that the man who is the accused is the man who committed the crime. If this is the evidence on which the court has to act, it is questionable. To support the identification in the court, that is, to corroborate the oral evidence in court, evidence of identification at an identification parade will be given. within a few days after the commission of the crime, when the identity of the culprit is fresh in the mind of the witness, he will be able to identify him at the parade. When this evidence is placed before the court can safely act upon the oral evidence. But evidence of an identification parade held by the police cannot be given because it is a statement made to the police that this is the man who committed the crime, and under section 162 CRPC, evidence of a statement made to the police during investigation cannot be given generally. So, in order to make such evidence of identification parades admissible in court, so as to corroborate the oral evidence that would be given, the identification parades are held in the presence of a magistrate who is a judicial officer. At the trial, after the witness who identified at the parade gives his evidence, the magistrate will be called as a witness. He will tell the court the various steps he took to see that the witness really picked out the accused at the parade without any police help, and then corroborate the witness by saying that the witness did pick out the accused at the parade. Just because the identification was made for the first time in the court, it does not become inadmissible, but evidence of identification of accused before the court should not ordinarily form the basis for conviction unless corroborated by previous identification in the test identification parade or any other evidence, though there may be exceptions to this rule. Evidence of test identification parade is not substantive evidence, whereas evidence given in the court is. Facts which fix the time and place at which a fact in issue or relevant fact happened are clearly relevant. If A is charged with murder of B, then the prosecution will have to establish when and where B was murdered and that A was at that place at the time when the murder was committed. Only then would the guilt of A be proved beyond all reasonable doubt. Facts showing relationship between the parties are allowed to be proved to establish the genuineness of the transaction between them. Where the validity of a contract is in question on the ground that it was caused by undue influence and consequently there was no free consent, the fact showing that the relationship existing between the parties is of such a nature that one of them is in a position to dominate the will of the other is relevant. The following facts are made relevant in proof of conspiracy under section 10 of the Act. The section states that when there is a reason to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons after the time when such intention was first entertained by any one of them is relevant. It is relevant as against each of the persons believed to be so conspiring in order to prove the existence of the conspiracy and in order to show that any such person was a party to it. What is conspiracy? Under section 10, conspiracy arises when two or more persons come together to commit an offense or an actionable wrong that is taught. Under section 120A of the Indian Penal Code, when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is criminal conspiracy. The word illegal under section 43 IPC includes everything which is an offense or which is prohibited by law or which furnishes a ground for civil action, which means a tort. Thus, the scope of the definition of conspiracy is in effect identical both under section 10 of the Evidence Act as well as under section 120A of the Indian Penal Code. The offense of conspiracy is based on the principles of partnership and agency, and just as in a partnership, every partner is a principal and agent vis-a-vis every other partner, in a criminal conspiracy also, being a partnership in crime, every conspirator is in a similar situation as against other conspirators. Like partners, conspirators are jointly and severally liable for the actions of the other conspirators in the pursuit of the objectives of the conspiracy. Thus, the acts done by anyone in furtherance of their common purpose is considered to be the acts of all. Ordinarily, a person cannot be responsible for the acts of others unless they have been instigated by him or done with his knowledge or consent. Section 10 provides an exception to this rule by laying down that an overt act committed by one of the conspirators is sufficient on the principles of agency to make it the act of all. But such concept of agency can be availed only after the court is satisfied that there is reasonable ground to believe that they have conspired to commit an offense or an actionable wrong. It is only when such reasonable grounds exist that anything said or done or written by any one of them in reference to their common intention thereafter is relevant against the others, not only for proving the existence of conspiracy, but also for proving that the other is also a co-conspirator. Any statement by an accused after arrest, whether a confession or otherwise, does not fall within the ambit of Section 10. The first condition for applying Section 10 is that the conspirators have conspired together. This condition will be satisfied even when there is some prima facie evidence to show that there was such a criminal conspiracy. If this preliminary condition is satisfied, anything said by one of the conspirators becomes substantive evidence against the others, provided that it should have been a statement in reference to their common intention. Once there is sufficient material to reasonably believe that there was a prior meeting of minds and connection between persons charged with a common design, it is immaterial whether they were strangers to each other or ignorant of the actual role each one of them played, or that they did not perform any one or more of such acts by joint efforts. The acts and statements of one conspirator would be relevant against the other conspirators, showing that such a person was a member of the conspiracy, but this cannot be used in favor of another conspirator for showing that he did not take part in the conspiracy. For example, two accused met a police inspector on the road who was conducting an investigation against one of them in a criminal case and asked the inspector to hush up the case for valuable consideration. A few days later, the other accused met the inspector at the police station and offered a packet of rupees 500, saying that the accused against whom investigation was pending had sent the money for hushing up the case. The two accused were charged with the offense of conspiracy to bribe the police officer. The question that arose was whether the statement of one accused at the police station was relevant against the other. It was held that the evidence of the conversation on the road showed that there were reasonable grounds for believing that the accused had entered into a conspiracy to commit the offense, and therefore under Section 10, the statement made by one of them in execution of the conspiracy would be relevant against the others. The next provision deals with facts which otherwise would not be relevant when would become relevant. Section 11 is described as the residuary section dealing with the relevancy of facts. Under this section, facts that can be proved are the facts which are inconsistent with any fact in issue or relevant fact, and facts which by themselves or in connection with other facts make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. But every fact which has some remote bearing upon a fact in issue cannot be proved. Otherwise, the very purpose of the theory of relevancy would be defeated. In order to make the facts admissible under this section, it must be shown that they have a proximate connection with the fact in issue or relevant fact. The following are the typical examples of facts that are relevant under this section. 1. Alibi or the plea that the accused could not have committed the crime because he was elsewhere. 2. Non-access in cases of questions of paternity where the man says that he could not have been the father either because he was impotent or he was at a different place at the time the child was conceived. 3. Self-inflicted harm, that is, the plea that, for instance, the alleged victim of murder in fact committed suicide. 4th, third person was guilty and not the accused. And 5th, the man supposed to have been murdered by the accused is alive. First is alibi. It is a Latin term which means elsewhere. Very often, accused is in criminal cases take the plea of alibi asserting that at the time of commission of the offence, he was not anywhere near the scene of the crime and was far away from the place of the crime. Where the question is whether A committed a crime at Calcutta on a certain day. The fact that on that day A was at Bangalore is relevant. Non-access, where the question is whether A is the legitimate son of B. The fact that B was in a far-off country at the time when A was begotten and the mother remained throughout in India establishes non-access. The fact that he did not have access to the mother of the child at the time when the child was begotten is highly inconsistent with the fact in issue that A is the legitimate son of B, and also makes the fact in issue that A is legitimate son of B highly improbable. Self-inflicted harm, where the question is whether A committed the murder of B by administering poison. The fact that B committed suicide by consuming poison is relevant as it is inconsistent with the fact in issue that A administered poison to B. The commission of a crime by a third person, where the question is whether A committed the murder of B by causing injuries. The fact that he was killed by C by inflicting injuries is relevant as it is inconsistent with the fact in issue that A committed the murder of B by causing injuries. Survival of the alleged deceased, where the question is whether A was murdered by B on a certain day. The fact that A was seen alive subsequent to that day is highly inconsistent with the fact in issue that B killed A, and also makes the fact in issue highly improbable. Facts showing probabilities. Evidence can be adduced of every fact which by itself or in connection with other facts makes the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. In cases where it is not possible to prove certain facts by means of direct evidence, the court has to be guided by the probabilities of the situation. Supposing the question is whether A committed a crime, the circumstances are such that the crime must have been committed either by A, B, C, or D. Every fact which shows that the crime could not have been committed by anyone else and that it was not committed by B, C, or D is relevant. Evidence of these circumstances makes the fact in issue that A committed the crime highly probable. Where the eyewitness testified that the accused hit the deceased from behind only once, whereas medical evidence clearly indicated that 3 separate incised wounds were inflicted upon the deceased, the medical expert opinion rendered the testimony of the eyewitness highly improbable. Thus, the facts or statements can be relevant under Section 11 if they do not offend against any other section of the Evidence Act relating to relevancy and admissibility, and if they render the fact in issue or relevant fact highly probable or improbable. This is about the rules regarding relevancy of facts under sections 9 to 11 of the Indian Evidence Act. Thank you.